Good morning, good afternoon, or good evening, depending on your time zone. My name is Maeve McDermott, and I serve as manager of the Climate Law and Governance Initiative. So on behalf of the initiative, thank you for joining us today during Climate Law and Governance Day for this session on advancing global accountability for corporate climate action, which is hosted by Melbourne Climate Futures, among other partners. And so with that, I will turn over to the chair of the session, Professor Jacqueline Peel, who is the director of Melbourne Climate Futures and is a professor at Melbourne Law School, and who is a leading internationally recognized expert in the field of environmental and climate change law. Among other achievements, she's an elected fellow of the Academy of Social Sciences Australia and has published widely in climate change and environmental law, including leading monographs on climate litigation and principles of international environmental law. So with that, I'll turn it over to you, Professor Jacqueline Peel.
Thanks so much, Maeve, and thanks everyone for joining us today for this legal roundtable on advancing global accountability for corporate climate action. I'm delighted to be chairing the session, and we are going to be discussing this issue with our fabulous panel. I'll introduce them all shortly, but it's a very timely topic for this roundtable today. Yesterday here in Baku at COP29, we saw the launch of the report Integrity Matters, The Hard Work Begins, which is a follow-up progress report issued by the UN Secretary General's high-level expert group on net zero. And the report assesses global progress on the implementation of high integrity net zero commitments, including by companies. So there's some good news in that report, mainly that there's a lot of activity, that we have over 1,000 of the largest 2,000 publicly listed companies that have voluntary net zero targets. That's an increase of 23% since June 2023, marked rise in Asia in particular. And many large companies around the world are already preparing to respond to mandatory climate disclosure regulations. We're seeing that most particularly emerging in the EU with the Corporate Sustainability Reporting Directive, and also in California and in my own home country of Australia, preparing to introduce mandatory climate disclosure reporting. But there's also challenges and headwinds ahead, and that's some of the things that we might discuss in the roundtable today. There's a severe lack of voluntary commitments in those company targets to phase out fossil fuel. And there's also a real need for increase in efforts to triple renewables, double energy efficiency, and also to ensure that those targets are subject to independent auditing, verification and assurance. So on that side of the ledger, where we're concerned with ensuring corporate climate accountability, we also began this week with quite a momentous decision, the issue of the appeal judgment in the Dutch case of Milieu de France versus Shell. And the original ruling of the Hague Court there had imposed an obligation on Shell to decrease its emissions by 45% by 2030 across its whole portfolio, including Scope 3 emissions. The appeal judgment walks back that finding of the need for a specific level of emissions reduction by Shell, but it still contains quite a lot of note in terms of the responsibility of corporate actors, and particularly major fossil fuel polluters, to reduce their emissions, and even begins to construct that in terms that we might recognise in international law. So to help us dig more into these issues and the other avenues for global accountability that we might consider or imagine for corporates for their climate promises, I'm joined by 4 wonderful panelists. My colleague at Melbourne Climate Futures, Janine Felsen, who also is participating as a negotiator at COP29 and was a member of the high-level expert group for the first Integrity Matters report. Joanna Setzer joins us from LSE, where she's an associate professor. Joanna is leading LSE's work at the Grantham Institute, producing annual global trends reports on the state of climate litigation and noting some of the trends around corporates. Haro van Asselt joins us from the University of Cambridge, where he's the inaugural Patten Professor of Climate Law in the Department of Land Economy there, and a very well-renowned expert on international climate law and its relationships with other parts of international law. And last but by no means least, Professor Sands, Philippe Sands, PC, who's Professor of Public Understanding of Law and Director of the Centre on International Courts and Tribunals at UCL, and also a very long mentor of mine, who I first co-authored his seminal text, Principles of International Law now, that we're taking over in the next edition with Lavanya and Rajamani. So I'm going to pose some opening questions to our panelists and invite some discussion. There will be time at the end for some questions from the panel to put to the panel. So if you'd like to do so, please put those into the Q&A function, and we'll try to get to as many of those as we can. So I might ask Janine, come to you first. Given this context of the reports that we're seeing coming out at COP about the focus that non-state actors and corporates in particular are making towards at least articulating net zero targets. What's needed, do you think, as a next step, particularly in the legal and regulatory area, to support more effective implementation of corporate net zero projects?
Thanks, Jackie. I think I will lead off from where you ended in regards to the recent follow-up report on integrity matters that Catherine McKenna introduced yesterday. On, where have we gotten with these 10 recommendations that the high-level panel had actually introduced? And of course, there was a lot of activity and excitement about it in Sharm el-Sheikh. Last year, there was a task force on net zero policy that was launched, headed up by one of the representatives on the high-level panel, along with several other co-chairs. And I think, something that we struggled with in preparing that integrity matters, the first report, was the very issue about regulation, because there's a whole lot of voluntarism across the board when it comes to the net zero commitments. And it's no surprise, in fact, that despite the progress, those points that you raise, and that was introduced in the Integrity Matters follow-up report, there's still a lot that needs to be done. And if our nerves are frayed because the planet looks like it's going down, the tube effectively, I think it's for good reason. When you look across the report that the Task Force for Net Zero Policy published, you'll see, the wide array of measures and regulation that are in place. But there is, as the Integrity Matters report points out, a lot of incoherence on policies. We've highlighted the importance of anchoring the transition plans or net zero commitments and transition plans to 1.5, but that's not really something that's common across all of these various measures, including regulation. So what has been proposed as a way forward is to try to look more closely at that level of coherence. And one of the areas where I think there's perhaps an opportunity to actually address that is with the upcoming NDCs, or nationally determined contributions. And in fact, perhaps one of the levers there is how government themselves can actually influence behavior through their targets under nationally determined contributions. Other issues, of course, if you look across the 10 recommendations from the Integrity Matters, the first report, of course, there are different aspects within which policy levers can actually be used to address the importance of having these various plans in place. What the second report does is to focus on increasing mandating of high integrity transition plans in standards and regulations. and consistent implementation of transition plan disclosure requirements and guidance across countries. I do want to stick a pin there, though, and highlight that one of the criticisms of the initial recommendations, the focus on disclosures, left a lack of focus on action. And I think that's something that has to be balanced out in any case. But nonetheless, the efforts towards improving disclosures is something that needs to be amplified. And of course, there needs to be better guidance across countries on just what those transition plan disclosure requirements might look like. In that regard, in terms of pushing for coherence, of course, it would be good to have some type of global baseline on transition plan disclosure. And there are already bodies that can actually help push for those. Some aspects of the Integrity Matters report recommendations that tend to be left on the wayside are those relating to other sustainability priorities like nature and just transition. So policies that implement these as complementary policies will be required, and that's another area that needs to be focused on. I will depart a little bit from what that report has stated and just highlight the importance of looking at other levers outside of a private sector and thinking more along the lines of empowering other actors to be able to actually have that potential to enforce or to address issues around integrity of commitments or announced plans, etc. And that's in relation to civil society. And that's a whole other area of law, I think, that's really important to be addressed. We have efforts around freedom of information for environmental related matters, the example of the Escazú agreement. I think things of that nature also have to be taken into account because we focus, yes, on the private sector and how regulation might be able to incentivize or disincentivise certain types of action. But there's also another layer of actors who need to be taken into account when we're talking about what needs to be regulated. And I'll leave it at that. Thank you very much.
Thanks, Janine. That's covered a vast amount of ground already, and we might come back to that question of how we empower our civil society actors to be holding the private sector actors to account. But Hara, if I could come to you, Janine sort of highlighted there the increasing amount of regulation and policy that we're seeing directed towards corporate pledges. But you've written also a lot about the corporate climate accountability gap. It might be good just to revisit how and why that does arise, particularly in international law, and whether cases like we're seeing the Shell judgment recently are addressing that gap, bridging that gap, or perhaps making it a little bit wider. Yeah, over to you, Hara.
Thanks, Jackie, and good morning, everyone. Thanks also, Jeannie, for those very interesting interventions just now. So the corporate accountability gap, I guess, arises for a number of reasons. Like, first of all, perhaps most importantly, we know that many private actors, many companies still have quite a long way to go towards aligning their activities with the 1.5 degrees goal. And you mentioned the Integrity Matters report from yesterday, but there's another report that came out yesterday from the Carbon Tracker Initiative, which found that not a single oil and gas company has Paris-aligned targets at the moment, just to give you another example. And likewise, we also know that other companies, including financial institutions, still are lagging behind in one way or the other. Moreover, and this is, of course, again, where the work by the high-level expert group and the Net Zero Policy Task Force comes in, is that we know that even those companies that do set net zero targets do not necessarily meet the minimum integrity standards, right? Like in the form of providing transition plans, in the form of setting interim targets, providing clarity on the use of offsets, or submitting progress reports. It's also important to note that there's also the flip side, another type of accountability gap, and that's of companies towards their shareholders and investors. And also here, again, of course, there's a lot of work on disclosure that is trying to address this gap, but we still see for many companies that they do not fully disclose the physical risk of climate change, the transition risk of climate change, and also, as we'll probably be talking about later, the litigation risk of climate change. Now, if we're talking about the second part of the question, and I'll talk briefly about the Shell case and what that means as well. But before I go there, maybe just as a reminder, right? Like, so if we're looking at international process and international law, we know, of course, that treaties in general do not set obligations for private actors. Maybe very exceptionally, but generally, like even if you look at the business and human rights treaty draft at the moment, it's about state parties, right? Like it's the obligations for state parties. And that's why I think also very helpfully the work of the Net Zero Policy Task Force is really about what can governments do rather than just looking at what private actors can do. But I do think there's been some interesting developments also within the UNFCCC process. In addition to the report and the work from the Net Zero Policy Task Force, what we had last year with the UNFCCC Secretariat launching consultations on the so-called recognition and accountability framework, really trying to figure out, well, how can we actually, as maybe also the UNFCCC Secretariat, as well as the high-level champions, right? So some of the actors, not necessarily the parties, but how can other actors within this broader UNFCCC ecosystem help to set minimum standards? And I think we've seen already some developments, for example, some minimum criteria, entry criteria for the race to zero. We see some increasing scrutiny of the thousands of pledges that are put on the Global Climate Action Portal. So I do think there is that role that can be played by the UNFCCC process, maybe broadly speaking. But then moving on to other areas of law as well, and I guess one of the areas to look at here specifically is human rights law, including also soft law that applies to businesses, right? Like, so we're talking about the UN Guiding Principles on Business and Human Rights, the OECD Multinational Enterprise Guidelines, the Global Compact, other soft law. And here, going back to the Shell case, both in the Court of First Instance, so the District Court decision, as well as in Tuesday's Court of Appeals decision, we see there's a very clear reference to, again, not just the hard law, the European Convention of Human Rights, but also increasingly these soft law instruments. And in my view, what was also interesting is the court referring to the developments at the international level, right? The General Assembly's recognition of the right to a clean and healthy environment, even references to other judicial decisions in other countries in the world that link human rights and climate change. And I think it's very clear that going forward, human rights, including the soft law that I mentioned, will play a role in bridging that corporate accountability gap. Now, of course, the question, and we can talk about this, and I know that Joanna has views on this as well. The question is, to what extent can human rights law and can that soft law point to concrete commitments? And this is, of course, what was the major change between Shell round one versus Shell round two. In round one, the district court indeed indicated, yes, we can derive a concrete emission reduction target for Shell from that body of law as linked to Dutch tort law. But in round two, basically, the Court of Appeal threw his hands up and said, no, we cannot derive a concrete target. Well, at least not the concrete targets that the plaintiff was calling for. So I do think that human rights law, again, going forward, and not just in my home jurisdiction of the Netherlands, but also in other jurisdictions, will play a role in helping to define and helping to close that gap. But I think it will be interesting to see how exactly it can be formed into concrete commitments. Thanks.
Thanks, Haro. We might stay on that theme of domestic climate litigation and turn to you, Joanna. Haro's mentioned there the use of soft law and also human rights as a way potentially to bridge the corporate accountability gap in litigation. You're tracking continually global climate litigation and the trends. What sort of trends are you seeing? And do you think that it's possible to derive perhaps almost transnational accountability principles that might be useful in this kind of context of holding companies to account for what they say they're going to deliver on climate change.
Sure. Thank you very much, Jackie. And I think it's a good point where Harrow stopped, because of course it's not that the Shell recent decision changes everything, but we have it at the back of our mind now in terms of how it confirms and challenges some of the trends that we were seeing. But I think first of all, it's important to have a big picture in mind and to zoom out. And if we look at climate litigation against corporations so far, it's a smaller amount of the total amount of cases, right? We're talking about 70% of cases more or less against governments and 25 against corporations. So we're talking about a small group of cases, which within that group, there's also a lot of diversity. So I think it's important also to have that. We can't say all corporate cases are Shell-like. This is a small group. And out of these, we try to separate what is the more strategic type of litigation from the everyday bread and butter issues. And we're talking about a group of 230 cases that are more strategic, trying to change corporate behavior through litigation. So hopefully this puts a bit into perspective. Now, what's also, I think, more very interesting in terms of general trends is that in the last few years, we started seeing not only a diversification from the US to other countries, and this is really like the last 3 years, but also a diversification of sectors. Unsurprisingly, in the beginning, the litigation was targeting the major fossil fuel companies. But in the last 3 years, we see a huge diversification. And I love that we call the rainbow chart that we have, because you have from 2015 that we tracked that basically three colors, cement, oil, gas, and then suddenly after 2022, you have 20 colors. You have the textiles, the financial sector, the food and agriculture. So we're seeing a lot of diversification of cases. And why is that happening? Well, first, because there was the wave of climate washing cases, which allowed us to see cases against not the usual suspects. And I like the example of Oatly, the oat milk that is one of the many companies involved in litigation, which is a completely different type of company than Shell, right? So you have that phenomena from the climate washing litigation, but also some more sophisticated litigation that understands the supply chains. So understands also the financial flows. And you have litigation being brought against banks, the BNP Paribas case, or shareholder cases, such as the one brought by INEA, Client Earth against INEA. So you have also different types of actors bringing the cases. So I think in terms of big picture, there is a lot of that. And now going more towards this kind of the international angle that we are focusing here, it's of course soon to say much, but there are two important angles, I think, that it's worth following. One is how the obligation from states, and this is the point that Harrow was making, the obligation of states has made into an obligation to corporations. And this is still an avenue that is being explored. So the moment that you have a successful case against the state, can that obligation somehow translate or be taken into an obligation against a corporate? And to a large extent, now of course back to the Shell decision, that happened still, so in Shell, the court, the decision from Tuesday did emphasize that there are shared responsibilities of states and privates, that everyone has a responsibility, so it's not just the states. And it did note that especially companies have products that contribute and that they have the power to address that. So we are yet to see to the extent to which one obligation and responsibility that was more straightforward for courts to accept and determine specific reductions will percolate to corporates. And then, of course, there's a lot of nuance, but I think one conversation I was having just yesterday with Professor Simon Dietz at LSE, and he was saying, well, basically, you know, a lot of the science that was challenged by Shell and that the court struggled to accept, ultimately we're talking about the same models, the same model that it's not a completely different model in terms of progressions and emissions. It's always the IPCC, and it's just that you zoom into the sectors. So in terms of the science, it's not that it's a completely different model. It's just the difficulty for courts to make that specific determination, and then we'll see how the duty of care and the human rights what role and how strong they can be. So with the duty of care, the big advantage now is that we're seeing a change in the regulatory system, where not only you have the instruments that have been mentioned, UNHPs and the OECD, but we are having in a domestic context legislation by several countries, and also in the EU level, requiring due diligence and transition plans for not only now states, but also for companies that need to have a plan, and that plan needs to be specific. So I think that's where I see the kind of maybe the future, the direction, where we will have through human rights-based claims, and specifically through due diligence regulation, clear directions for what companies are expected to do, and potentially litigation that will challenge when that's not taking place. So I think I hope that we have opportunities to go around and kind of maybe bring together several of the angles, but there's certainly a lot still to discuss, and I'm looking forward to that part.
Thanks, Joanna, and thanks for giving us that sort of zoomed out perspective on climate litigation. And of course, in the corporate area, that it is a small subsection of the overall cases, and many of the cases are focused on greenwashing claims or disclosure claims, these bigger cases around human rights. But certainly those ones do capture a lot of attention. Philippe, maybe if we're keeping this zoomed out perspective, but transitioning away from domestic law accountability to international accountability. A lot of what we've seen in the climate litigation space has been at the domestic level, but 2024 has been an interesting year where we've seen more actions in the international law space, with RCJ advisory opinion, the Inter-American Human Rights Court, the rulings of the European Court of Human Rights, and also the International Tribunal of the Law of the Sea. So perhaps illustrating some of the diversity of mechanisms that exist in international law. You've obviously had very extensive experience with international litigation across many different fora. What sorts of international accountability mechanisms do you think we could or perhaps should be looking to try and ensure companies deliver on climate promises and meet that responsibility for dealing with climate change?
Thanks a lot, Jackie, and it's really great to listen to actually all the initiatives. Obviously, it's very difficult to keep up with everything that is going on, so this is incredibly useful. And it seems on corporate accountability, there's a whole package of issues, and we've heard about the domestic context. At the international level, we're all aware of things that are going on. They tend to focus not on corporate accountability, but state accountability. There's cases before various international human rights courts. There's, the well-known case against Switzerland at the European Court of Human Rights. There's an advisory opinion procedure at the Inter-American Court of Human Rights. There's the Int'l advisory opinion, which has come down. And on the 2nd of December, there will be proceedings starting at the International Court of Justice. I mean, it's an extraordinary procedure. It's the first time in the history of the court that a request from the General Assembly has gone by consensus. I think that's a bit of a two-edged sword, actually, because it sends to the judges a signal that somehow the question that has been put is as acceptable to small island states on the one hand as it is to Saudi Arabia and Qatar on the other hand. And that will, I fear, tend to push the court towards the centre rather than to come out with the kind of decisive opinion that they gave in the Chagos case, for example. The questions also, very frankly, are not very helpful to the court. They are so general, they deal with so many instruments. The judges are really not on top of climate change. So I really would not hold your breath about what they're going to do. I mean, the Int'l advisory opinion is helpful up to a point, but it's, in a sense, platitudinous, just so general that it's really hard to see that advisory opinion materially affecting human behavior, state behavior, or corporate behavior. I've always thought that at the function of ITLOS and ICJ, the real issue is to do something that assists national courts, because that's really where the rubber hits the road. It's not going to be the international level. And in that regard, I think it's really issues like making clear the science. I sort of regret that ITLOS didn't go further on the science. I hope that the ICJ goes much further on the science and basically saying there's a consensus and drawing out the consequences for a state of failing to take account of the science in going forward, which of course has spin-off implications for the corporate sector. So there's an indirect impact of the coming ICJ proceedings and maybe also the ITLOS proceedings and the human rights proceedings for the corporate sector. But I do wish ITLOS had gone further, and I hope the ICJ will go further in what it says. But as I said, I would not hold your breath. There are 100 states and international organizations participating. They get a slot of half an hour each over the course of 2 weeks. And frankly, I really feel for the judges having to listen to that stuff for 2 weeks. It's going to be pretty soul destroying. And I think it's, to be honest, not going to be very riveting. And so I would expect that the ICJ comes out with something that is, bread and butter, middle of the road type of stuff. To me, the much more interesting development is the one that actually takes place coincidentally that same week in The Hague, which is the first ever effort to put ecocide onto the statute of the International Criminal Court. And a group of countries have now made a formal proposal. That's the first time that it'll happen, that it's happened. And so the Assembly of State Parties now has on its agenda for the first time putting the protection of the environment through criminal law at the international level on its agenda. Now, I'm not starry-eyed about the criminal law. We haven't heard, interestingly, about the criminal law at the domestic level. We've essentially heard about tort-type cases, which I think are very, very important. But I think one of the most significant developments is the use of the criminal law at the domestic level. The EU, as you know, has a new directive. Many countries, Belgium and others, are now pushing for criminalisation at the domestic level. Mostly individuals, but some corporate. To put my cards on the table, I've always thought that corporate criminal liability is not a particularly useful thing to do because they basically pay their fine and then get on with it. What really concentrates the mind is individual criminal liability, chief executive officers, shareholders, and so on and so forth. And I know that from my own work in other issues, that if you really want corporations to change their behavior, you basically go for those who are responsible for running the corporations. And so I'm rather partial to individual criminal liability. The ecocide initiative, of course, will take time to get up and running, and it doesn't focus, of course, in the ICC context on corporate criminal liability. But that doesn't mean it doesn't have very serious consequences in relation to corporates, because the individual criminal liability is not going to be limited just to those individuals who are responsible for state behaviour. So it's not just a British Prime Minister who authorises a new coal field, or gives hundreds of licenses for oil exploration in the North Sea. There are people who are saying that kind of behavior is ecocidal and should give rise to individual criminal liability, not just at the domestic level, but at the international level. And I think that's the trajectory that is being taken. But I think more significantly is individual criminal liability at the domestic and international level for chief executive officers, chief financial officers, majority shareholders in basically running companies in a way that fails to take into account these international obligations. Again, I'm not starry-eyed about it. I don't for a moment imagine that with the arrival of criminal liability at the domestic level or at the international level, somehow corporate behavior is instantly going to change. But it does have the effect of concentrating the mind. And we know that when we came up with the definition of ecocide a couple of years back, I co-chaired a working group. We purposely did not include examples of what would be ecocidal behavior under our definition. And the reason for that was strategic. Once you have a list of the kinds of things that might be considered to be ecocidal under international criminal law, you've got opponents for the project. And you can't have a list of ecocidal things without having climate change in some way on the list. And so the view was taken, I think rightly, that one should not include specific examples of the kind of behavior that might be ecocidal. But various newspapers who wrote about it, including, interestingly, there's a very good piece in the Financial Times. I did an interview with one of their journalists, and she pressed me on can I give examples? And I said, no, I'm not going to give examples. But she, in her article, then did come up with examples. And of course, she singled out the chief executive officer of ExxonMobil as the kind of person. And I just know from anecdotal tittle-tattle that definitely reached the top. And I think, stepping back, the role of all of these initiatives, whether it's domestic tort, domestic criminal, international human rights, it's essentially about changing consciousness. After 30 years of climate change regulation, and as you know, Jackie, I was present at the very first meeting in 1990 and at all the negotiations. So I'm really somewhat skeptical about the international regulatory framework. And I'm even more skeptical, frankly, about soft law in terms of really having impacts. So I think it's basically time to make the rubber hit the road and focus on key individuals and do that at the domestic level and at the national level and move into the criminal law context. And that should be added to the list of regulatory and legal arrangements that we have. It will not solve everything, but that's certainly where I'm putting most of my energies in the coming period. And I do want to devote time to that. I think the criminal law is underexplored, and I think it's ripe for exploration.
Thanks, Khalif. I think you've offered us both a reality check on expectations around the ICJ advisory opinion, the ITLOS advisory opinion, and a bit of a call to action to look potentially at other avenues that target individuals, particularly no corporate CEOs who might be putting up polluting companies. I just wanted to give the other panelists an opportunity to respond to anything that you've heard, to offer further thoughts. So that we've canvassed a lot of ground from the sort of differences between state accountability and corporate accountability, and whether there are sort of ways to link those two. The role of corporate climate litigation and whether it can offer any redress or accountability mechanisms, and also looking at these questions of soft law, human rights, how they might play some, and even into criminal law, play some role in enforcing climate policies. So I just wanted to open the floor to our panelists if you would like to come in and respond or further comment on anything that you've heard. I can see you've come off mute, so I'll give
Yep.
the floor to you.
Well, maybe just to echo Philippe's point, which I think is very often forgotten in these types of discussions, and that's the point of urgency, right? Like like we can talk about disclosure till the cows come home, but that's not going to change things rapidly within companies, right? Like, so it will change things gradually, but it's a long-term theory of change. Right, like, so first disclosure, then maybe following disclosure, there will be pressure from shareholders and investors, and then over time there will be action. By that time, we'll be past 1.5 degrees, right? Like, so I think this is just something to keep in mind when we look at the individual accountability measures, right? Like, so whether it is indeed climate risk disclosure, whether it is due diligence laws, whether it is also litigation, when we're assessing the effectiveness of all of these approaches, we need to always keep in mind, well, what will bring about the change quickest? So I think that's just for me like a reflection that we probably all ought to keep in the back of our minds.
Yeah, it's an excellent point, Haro. I mean, I think there was a lot of excitement at COP29 yesterday talking about the Integrity Matters report and so on and the progress, but also a recognition that we can't wait another 20, 30 years for all of that to roll out in its long-term theory of change, as you say. So what are those intervention points that we might push on to increase pressure? And Janine, I don't know if you had any reflections on the extent to which this matters in the negotiations process, or whether there can be a sort of complementarity between the negotiations and all of this other stuff that's occurring outside that can produce some of that needed urgency.
Yeah. First observation is, I mean, we're talking about different levers to influence change. So you can have the top down, and then you can have more of a bottom up approach, where you have litigants going after whether it's corporates, whether it's corporate individuals, or individuals of corporations, and then you have the state level. And I don't think you can throw the baby out with the bathwater and say, this one doesn't work, so we'll just all put our eggs in this basket. I think you have to use all the tools in the toolbox. That's the approach that we necessarily have to take. I think there are some valid points in relation to what litigation at the global level might, how that might impact negotiations. So far, it's been very limited. And except to the extent that there has been some level of amplification of some of the issues, especially from a small island developing state perspective, of the issues that sort of drive the arguments around why we need more action in terms of mitigation, why we can open up other fronts for more integrated approaches on climate, as well as ocean, for instance, with the Int'l case. I'm not quite sure how the ICJ will turn out. It's everyone's guess at this point in time. But to the extent that there may be efforts to address issues around duty of cooperation and how that can eventually play out in the context of the negotiations, I mean, those are areas that can be explored further. It's very hard to say that there is an immediate impact on negotiations from these decisions that have been taken. It really is up to individual parties or groups of parties to try to use or extract what they can use from these various decisions in the context of negotiations. But I can tell you, it really isn't having an impact on the climate finance discussion right now, as much as I would like it to. Thanks.
Thanks, Janine. Yes, I'm not sure that anything's having much of an impact on speeding up the climate finance negotiations just at the moment. Hit a little bit of a wall. Joanna, there were some provocative comments there offered by Philippe about the extent to which we can and hope for good decisions emerging out of the ICJ and other international litigation forums that might flow through to state accountability and then corporate accountability. I just wanted to give you the floor if you've got perspectives that either agree with Philippe or take a different view on the role of those international litigation avenues.
Yeah, well, I think I want to take his point about how we sometimes expect too much from, for instance, from the ICJ or from the international regime in general, and that we need some more immediate, stronger remedies and options. And I think that when I was listening to that, it made me think that we are seeing in the domestic litigation some alternatives that I think are maybe where we will see that change happening. So yes, individuals being involved in litigation rather than behind the corporation, that is one very interesting angle that definitely I've done some interviews also with corporates, and there is a clear sense that when their name is directly involved, it becomes then it's an issue. It is different for the board of directors and the individuals in that board to be involved in the litigation rather than Shell, and their exposure, their names that are out there in the media, their families asking them, what is this, is a very different situation than the company that they work in being involved. And I think similarly there are, I'm thinking about these recent cases in Brazil where the court determined the payment of climate damages. And it didn't do that along the type of cases that we're seeing in the US or Univ versus RWE, that they're seeking that compensation for attribution, and that of course the science exists, but by the time you prove everything, you had another 10 years going. And what these Brazilian cases are doing is something more straightforward. So there is illegal deforestation in the Amazon. What is the area that was deforested? Okay, that's the area. How much? It's very standard calculation in terms of the emissions, and they use the OECD price to calculate times whatever dollars, and we've seen companies being told to pay millions of dollars, in Brazilian reais, even more, just as a simple calculation of the area of the climate damage of the area that was illegally deforested. So I think there are other ways that you hit the target quicker and without so much effort and need for evidence or challenges around this, whether it's soft law or not. And this is where I have more hope that to take the straighter line and go directly in those that are taking the decisions that shouldn't be taken at this point, or for instance, finding ways to ask for damages that are not, the billions that will break the company, but it will hurt, and it will hurt at the right amount for them to make changes.
Yeah, thanks, Donna. I think we're all looking for those intervention points that might be action, and it's clear that a strategic approach is needed at this time. I think we might now go to some of the questions that are coming in, but I did notice that there was one sort of picking up on the question of how perhaps businesses or those who advise them, their legal advisors, could help translate these messages of a need for actual follow through on corporate targets and so on. So there's a question in the chat that's essentially asking what practical advice we might all have for either domestic lawyers or others advising corporates to help the rubber hit the road in terms of greater corporate accountability. So any advice that you might want to share in that report for those who might be tuning in. Haro?
If I may, like, it's a very short answer. It's like make 1.5-degree aligned transition plans now.
And there's lots of guidance that's emerging about what that might look like too. Any other responses on that question?
Well,
Philippe, there's a
yeah, I mean,
sorry.
for the I mean, for I've been looking at the questions and they're very interesting and quite a number coming from sort of corporate legal advisors. I mean, the practical issue, I think, really is a sort of lack of education and a lack of understanding, which is a generational thing. Wearing another hat, I sit as an arbitrator in international investment disputes. And it's just staggering how little information people have about climate change in my generation or people of my sort of generation, because we never studied environmental law. They're totally not focused on it. And so, in a sense, following on from Harrow, I would say it's really about developing programs internally in the corporation, which are essentially educational, but also linked to the personal and corporate consequences of failing to take this seriously now. That it will have long-term consequences for the company, and it may have long-term consequences for the individuals who are in decision-making authority. But it is, there's a lot of assumptions about how much information people have about what's going on climate change. I mean, whether it's sitting with arbitrators on cases that raise environmental issues, where it just becomes painfully obvious that the state of knowledge is literally zero, to going to a conference in The Hague and finding yourself sitting at a table with a number of judges from international courts and tribunals who'll just say, yeah, we've got these issues about climate change coming up. Frankly, we know nothing about climate change. So for the younger people on this call, you've got this assumption that everyone knows about climate change, everyone knows about 1.5, they really don't. I mean, they really are not focused on it. And I just think internally in the corporations, just redoubling efforts on educational programs and the legal consequences of failing to take account of these issues is the simplest and most direct route to beginning to change consciousness.
Yeah, so I think that's a really important insight and a role that internal legal advisors can play as well. And just thinking back to your comment about transition plans, Taro, at the launch of the Integrity Matters, the hard work to be done report yesterday, one of the comments was that transition plans need to become a real concept for companies linked to their own internal risk management. Otherwise, they're sort of like, why do I care? And this sort of spelling out the personal liability consequences for boards of directors on the offices is one very clear way to make that concrete, and the need for good, credible transition plans. There's a question that I think would be good to get to, which is in terms of global accountability on corporate climate action, how can that actually support and improve social and economic well-being of the population as well? So a lot of stuff in the corporate space tends to focus on mitigation, emissions reduction, but what about the broader social objectives, whether that's around protection of nature, just transition, addressing social inequities? Is trying to hold companies to account on avenues for addressing some of those different issues? Joanna, I didn't know if you wanted to come in on that, because you've been looking a lot at sort of a new phenomenon of just transition litigation.
Sure. Yeah, and it's a very important question, because at least I have been focusing on the litigation that translates those conflicting interests. So what happens when courts are dealt with two important, worthwhile defending rights? So, for instance, protecting jobs and indigenous communities or climate. And that will happen, for instance, when you have cases involving closing coal power plants and what happens to those workers, or in the renewables, what happens when you have indigenous communities, and there are a few cases like that, where their land is being used for huge solar panel farms and they're losing their land. And or we have the kind of the green situation. So the recent case in India where the Supreme Court had to decide between potentially protecting an endangered species, the great Indian bustard, and a cheaper way to have the lines transmitting energy from renewables, which it's again something that you would like to promote. So what these situations show is that not, I guess, when we're talking about the fossil fuels and the NGOs, it's you have a good and bad, the goodies and baddies situation, which is very unusual. And even in that one, there is nuance, of course. You're like, okay, so if Shell is not doing, another Saudi Aramco will be doing, and they have their standards are worse. So one interesting angle that I find is that the law is constantly seeking for that certainty, that straightforward, good and bad, right and wrong. But often in these cases, that's not going to happen. And the court will have to decide between important, equally sometimes important interests. And so I think if we go back to, I guess, the Great Indian Bustard case, the court said, well, look, yes, the bird is important, but it's going to be economically impossible to dig across the desert to have the wires going underground. So it said, what else can we do? How can we protect this bird and at the same time allow the renewable electricity to cross the desert? So it came up with some create whatever places for the birds to breed and protect in different ways. So you also see how often there's this, you will have to be creative and come up with something which is not not the A or B that you began with. And this will require from courts, from lawyers, this elasticity, this flexibility, which the law is not often the best to provide, but it will have to.
Elasticity, flexibility, and creativity is certainly required. Not always something that we see from courts, and particularly highlighted in comments before about certain courts or in certain areas of the legal profession. We might not have the underlying scientific understanding to get to those issues, that is in with that kind of issue. But Janine, I just wanted to come to you because you sort of pinned before, metaphorically, I think, in a question around the too much focus on disclosure in the sort of regulatory space, potentially as sort of keeping out of mind some of these broader questions around how corporate behaviour might affect social just transition issues and so on. So I wanted to give you some space to come back to that aspect about whether we're focusing too narrowly on sorts of things around disclosures and transition plans, and as we need to be thinking more broadly in the regulatory space as well as the litigation space.
Actually, Jackie, I was just thinking, there's a very strong pivot within. I mean, I work a lot in climate finance. A very strong pivot towards the private sector taking on a more active role in actually addressing some of the needs of developing country parties, and that was triggered by the question earlier in the chat and that you just raised And I think what would be interesting is how governments, through their policies and measures to sort of catalyze private finance, can actually create measures for accountability for the private sector. So, there are different reporting frameworks that the UNFCCC has, the United Nations Framework Convention on Climate Change, sorry for all the acronyms. And we don't pay a whole lot of attention to those until there's a COP conference of the parties coming up. But I think those will probably feature a little bit more significantly as we face some of these larger issues around how quickly we're advancing towards or overshooting the 1.5, as it were. So I'm interested in actually thinking about accountability and regulation or regulatory measures that then address that component of private sector picking up the bill in a sense to actually support a public good effort. So that would be in relation to adaptation, it could be in relation to loss and damage, but obviously it could be in relation to some of these issues around emissions reductions within developing countries. So, I mean, I think it's an interesting space to examine. It obviously comes more from a climate finance perspective. We're not talking about litigation, but this is exactly what we're talking about right now in the COP. And next year, there's another opportunity to address how exactly we see finance flows shifting towards low emissions, climate resilient development, again, with a just transition perspective. And here we will look at global policy, potential global accountability that directly impacts upon private sector actors or non-state actors. Thanks.
Thanks, Janine. There's more questions appearing in the chat, but I just wanted to give our two discussants, Roanna and Rebecca, a chance to pose any burning questions you have for the panel after listening to the discussion. So, Roanna, I might turn to you first if there's, and feel free to pass if you just to forgo the opportunity. But Rowan, I'll come to you first and then to you. But
sorry, very quickly, if I may interject, we have 8 minutes left for the session. Just want to keep time. Thank you.
I'll be very quick then. Thanks, Jackie. Thanks, everyone on the panel. I did wonder, we've been talking about lots of different mechanisms and interventions for leveraging corporate climate accountability. And I wondered if you had any views on how well those mechanisms are currently speaking to each other. Are the developments in litigation filtering through to developments in mandatory due diligence or disclosure requirements, or vice versa?
thanks, Joanna. That's a great question. Anybody want to quickly respond on that one, Harry?
Yeah, well, very clearly, because I wrote an article about at least the linkages between litigation and due diligence legislation, and I think there are a number of them, right? Like, so one of them is due diligence legislation forming the basis of for further litigation, and I think Joanna was referring to this as well earlier on. And basically, for those companies that do not come up with the plans that they're required to, that could indeed form a basis for litigation. Also, due diligence legislation can be a response to litigation, right? It's basically litigation can point to the corporate accountability gap, which might then be filled by due diligence legislation. So the number of linkages that are taking place there. Linkages which I think are also very interesting to explore now are increasingly between what's happening at the UNFCCC level, what's happening in terms of private initiatives to address their own accountability gap, which again I think is going to be very hard. But like, so if we look at one of the recommendations from early this year from the co-chair for the recognition and accountability framework consultations that I mentioned earlier, and one of the recommendations there is to translate some of these voluntary initiatives in enforceable legal standards, Not sure if that's going to be feasible, but I do think that's an interesting potential interaction that could be further explored.
Beck, I'll give you an opportunity to ask a very quick question if you've got one that you'd like to direct.
Yeah,
And
sure.
I'm aware of
very aware of the time. Just a question around, in Australia, we have mandatory disclosure legislation coming in next year, and there's going to be a moratorium on litigation against corporate sector actors from the public sector, from civil society. All litigation is going to be have to come from our public regulator for a few years. So I'm just wanting to know if anyone on the panel had any reflections on, I guess, the limitations of litigation as a tool and why that moratorium might be proposed. We all like to talk about litigation, but yeah, some reflections on the limitations of it and then what needs to be balanced with it as well.
Anybody quickly like to take that, Joanna?
I think I can try a quick one because so litigation clearly has a role in this story, even if it is to guarantee its absence. So I think it goes back to that point. The best litigation is the litigation that was never filed, the case that was never brought, but that the risk is so present and that is taken seriously enough to change behavior. And to me, that moratorium says a bit to that, well, it's good. We'll guarantee that you won't be litigated against, but that might change in the future. But I find it actually quite helpful. I think it confirms that litigation has a role, because otherwise also they wouldn't be fearing it. So I consider the risk of litigation growing a very positive message in changing behavior. And so I like that moratorium to an extent.
I agree with Joanna. I think it's amazing. I wasn't aware of that. I mean, it really is staggering, and I think Joanna's absolutely right. It's because litigation works as a tool of changing consciousness. But embedded in the question, which is really very interesting, and Joanna's point, is a really more fundamental question that I've been thinking about at the international level, which is actually the relationship between the legislature, the executive, and the judges. And in a sense, the whole ICJ thing has happened as a reflection of a frustration that the legislation has failed. I mean, let's just be frank about it. It has completely failed. After 30 years, we have not done what we needed to do, unlike ozone or a couple of other things. And so into that void, those pushing for the ICJ have essentially prompted the judges. But that raises a really fundamental question. I mean, I read, and Harrow, your piece is really wonderful and very helpful. I'm really grateful to have had it. I have a certain sympathy with the judges of the Court of Appeal. I mean, they're put in an impossible position. The executive has failed, the legislatures have failed. So what? The judges now have to come in with quantitative targets for an individual corporation. That really isn't the function of judges. I mean, we can celebrate the district court decision from a few years ago because it had a galvanizing, catalyzing effect. But put yourself in the position of the judges. I mean, it's an awful position to be in. The states at the domestic level internationally have failed to deliver. So now these poor judges at the ICJ are being asked to step in, and those who are pushing for that agenda are going to be disappointed because it's not the function of judges to legislate. And the point made by Joanna, I think, is right. It reflects a fearfulness. But on the other hand, the move towards legislation hopefully will catalyze further action at the legislative and regulatory front. And that's what we need to be looking for. But let's think a little bit about the poor judges and the burden that is placed upon them at the national and international level by our total failure to regulate and to legislate. It's shocking. I mean, we've got to call a spade a spade. We have failed completely over 30 years. What's going on in Azerbaijan right now is a total disgrace. I mean, the story, in one of the papers this morning, experts saying the system has failed. It has failed. We have failed to deliver. and it's just time to call a spade a spade.
Well, that's definitely your specialty, call a spade, and it's probably a good point for us to conclude the panel. I do like Joanna's point that, you know, probably litigation's made it when everybody starts to hear it to some extent, but also just pointing across the panel to the deep interrelationship between what's happening at the regulatory level in legislatures and also in the courts, even if you do pity them fully. But thank you very much to all of our wonderful panel for this session, really rich discussion, and I hope our audience also enjoyed the proceedings. Thanks very much, everyone, for joining us for the roundtable.